Welcome to the House of Commons Standing Committee on Health. The committee is meeting to resume meeting number 46. Pursuant to the motion adopted on June 21st and the motion adopted on June 2nd, we are resuming our study on the emergency situation facing Canadians in light of the COVID-19 pandemic. I would like to welcome our witnesses today. We have from the House of Commons, we have Mr. Philippe Dufresne, Law Clerk and Parliamentary Counsel, and Michelle Bedard, Deputy Law Clerk. From the Office of Privacy Commissioner of Canada, we have Mr. Daniel Terrien, Privacy Commissioner of Canada, and Mr. Gregory Smolinek, Deputy Commissioner, Privacy and Promotion. And from the Office of the Information Commissioner of Canada, we have Ms. Carolyn Maynard, Information Commissioner of Canada. I understand that Mr. Terrien has to leave somewhat early, so we will start our opening statements with him just in case. And I will invite the witnesses to make a 5-minute statement, and I will indicate when your time is roughly up with the yellow card and when it's actually up with the red card. And when you see the red card, do please try to wrap up. You don't have to stop instantly, but do try to wrap up. So with that, I will invite Mr. Terrien, Privacy Commissioner of Canada, to make a 5-minute statement. Thank you.
Mr. Chair, just quickly before we begin, just as a matter of procedure, did we not invite someone from the Privy Council office to appear today?
We did, but they were unable to attend due to lack of notice. So we'll carry on with the Mr. Terrien. Mr. Terrien, please go ahead if you have a statement.
Merci beaucoup, Monsieur le Président.
Thank you to the Chair and members of the committee for your invitation to share our views on your current study. I'm accompanied today by Greg Smolinek, the Deputy Commissioner for the Policy and Promotion sector. Due to a prior engagement, I will not be attending this meeting for an hour, but Mr. Smolinek will remain to address any questions that arise afterwards. I'm here to speak to you today about what the Privacy Act does and does not allow with respect to the production of documents under provisions of the Act related to disclosures of personal information. Let me begin by stating that the role of the Office of the Privacy Commissioner is to oversee compliance with the duties and obligations set out by Parliament in both the Privacy Act, the Public Sector Law, and the Personal Information Protection and Electronic Documents Act, or PIPEDA, the Private Sector Law. The Public Sector Law, the Privacy Act, enacted in 1983, applies to the personal information handling practices of federal government departments and agencies. The Privacy Act defines personal information as information about an identifiable individual that has been recorded in any form. The Privacy Act creates legal obligations for departments and agencies by stating that personal information collected by federal institutions can only be used for the purpose for which it was collected, for a use consistent with a purpose, or for a purpose specifically provided under Section 8.2 of the Act.
Information cannot be disclosed without consent unless exceptions delineated in Section 8.2 of the Privacy Act apply, two of which are most relevant for this discussion. The first I would highlight is subparagraph 8.2m. This provision allows for the disclosure of personal information where, in the opinion of the head of the institution, the public interest clearly outweighs any invasion of privacy that could result from the disclosure, or if the disclosure would clearly benefit the individual to whom the information relates. Fundamental to this exercise of discretion is that there must be a clear public interest in the disclosure. The discretion to disclose or not to disclose personal information lies with the institutional head. The second relevant provision is subparagraph 8.2c of the Privacy Act, which allows for the disclosure of personal information to a court, person, or body with jurisdiction and the power to compel the production of information through the issuance of an order, subpoena, or warrant. In relation to this provision, we recognize Parliament's authority to compel the production of documents that may contain personal information and acknowledge that the Privacy Act therefore allows for the disclosure of personal information to a committee. In previous instances where this issue has arisen, we have recommended that committees explore a range of options to ensure that the authority of committees is exercised in ways that do not unduly invade on privacy. For example, mechanisms that might be considered include having committees come to an agreement that they will limit the personal information sought to only that cases which is clearly necessary to resolve the public interest at issue. Another possibility would be to hold meetings in camera where personal information is to be examined and discussed, or ensuring that there are proper procedures for securing that information once it is in the possession of both the committee as a whole, as well as individual members. These are examples of privacy protective measures.
Sorry, Mr. Chair. Sorry to the witness, but I believe the bells are ringing.
Yes. Very well. Also, my apologies to the witness, and we do require unanimous consent to continue. Do we have unanimous consent?
It's 15 minutes, Mr. Chair.
I'm sorry, 15-minute bells?
Yeah. 14 minutes at this point.
So I propose we continue for at least till the end of Mr. Therrien's statement, which is actually, his time is almost up, but let's give him a couple more minutes to finish and then revisit the matter at that time. Is that acceptable? I think so. Very well. Go ahead. Sorry for the interruption, Mr. Therrien. Allez-y, s'il vous plaît.
No concern. I had essentially finished. So our point is that even though a parliamentary committee can compel the production of personal information under its authority, and that there would be authority under the Privacy Act for the disclosure to a committee in those circumstances, we suggest that committee take privacy protective measures to minimize privacy risks in that exercise. That's the end of my statement. And as indicated, Mr. Smolinek will be able to take questions if I have to leave shortly.
Well, thank you very much for your statement, and thank you for being able to attend. So once again, as I indicated after the witness's statement, we shall revisit the matter. Do we have unanimous consent to carry on any further?
No.
No, we do not. Therefore, we will suspend and we will resume after the votes are done. Please do try to get back here as soon as possible after the votes. So thank you all, and we are suspended. is resumed. So we are resuming meeting number 46. And we've heard from the Privacy Commissioner, and we will carry on with witness statements. I will invite Mr. Dufresne, Law Clerk and Parliamentary Counsel, and to make your statement. Please go ahead, sir, 5 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair, members of the committee. Thank you for inviting me to appear today. As Law Clerk and Parliamentary Counsel for the House of Commons, I'm pleased to be here to answer your questions. I'm accompanied by Michel Bédard, Assistant Law Clerk and Parliamentary Counsel, Legal Affairs. I hope my answers will assist the committee in its deliberations.
Did a motion on October 26, 2020, which instructed this committee to undertake a study on the emergency situation facing Canadians in light of the second wave of the COVID-19 pandemic, and ordered the production of documents from various government departments and ministerial offices relating to this study. The House's order required that before their tabling in the House and distribution to the committee, all documents be vetted by my office for matters of personal privacy information and national security, and for the category of documents relating to the COVID-19 vaccine task force and its subcommittees, that they be also vetted for information, the disclosure of which could reasonably be expected to interfere with contractual or other negotiations between the government and a third party. On November 24, 2020, the Clerk of the Privy Council, Mr. Ian Shugart, testified before the Standing Committee on Finance that the documents responsive to the House's order could constitute millions of pages. On November 27, 2020, I appeared before this committee and confirmed that I would devote close to 100% of my office's resources to the review of the documents in order to meet the 7-day timeline provided in the order, and that we could review up to 50,000 pages during that 7-day period. The same day, this committee adopted an order asking my office to prioritize the order in which we vet the documents, and confirming that we could obtain an extension of time to review them if necessary by reporting to the committee. The order also stated that all documents were to be circulated to the committee in both official languages. This became the second report of the committee to the House, which was adopted on December 4th, 2020. On December 7th, 2020, my office received approximately 5,000 documents, totaling almost 27,000 pages, from various government departments and ministerial offices, which we vetted in accordance with the House's order and within the 7-day time period prescribed. In the letters accompanying the documents, the government indicated that my office could expect to receive subsequent batches of documents from the government. The majority of the documents provided by the government were only in one official language. Dès que nous avons reçu les documents,
as soon as we received the documents, I wrote to the Clerk of the Privy Council to confirm whether the government intended to provide translated versions of the documents, and if so, when we could expect to receive them. In his response of December 18, 2020, Mr. Shugart indicated that he believed that the committee, following the committee's second report adopted by the House December 4, 2002, my office was in the best position to determine the order and content of the translation work. On December 22nd, I wrote to Mr. Shugart indicating that the government has an obligation to produce documents in both official languages pursuant to Section 8 of the Official Languages Act and Standing Order 32.4, and that Standing Order 32.4, and that the committee's second report did not diminish this obligation. I said that we would send series of documents received to the Translation Bureau on behalf of the government, and in the future we would expect that the government would take measures to ensure that the translation of all other documents produced be done in a timely fashion so that we would receive the documents in both official languages so that they could be tabled in the House and then sent to the committee once our process for approval was completed.
My office subsequently received additional documents from the government. So on February 3rd, I wrote again to Mr. Shugart asking when my office could expect to receive translated versions of the documents so that they could be tabled in the House and distributed to the committee. On February 26th, I received correspondence from the Deputy Clerk of the Privy Council indicating that the documents were being provided in the language in which they were available in the government systems to produce them as quickly as possible, and that given my office's role in determining the priority and sequence for vetting and distribution of documents, the government's position was that we were best placed to determine the order in which documents should be translated and to access additional funding from the Board of Internal Economy of the House of Commons. The Deputy Clerk also advised that the government expected to provide documents in response to the House's order on a monthly basis. On March 2nd, 2021, I reported to this committee on the issue and reiterated my position that it is the government's obligation to provide bilingual copies of the documents. I also sought instructions from the committee about how it wished to proceed with respect to the translation of the documents for the 4th, 5th, and any subsequent batches produced by the government. We have to date been able to provide 6,307 documents to the Speaker for tabling in the House. On February 12th, 2021, this committee adopted a motion instructing the chair to inquire as to whether the contracts for Canada's 7 vaccine agreements had been provided to my office in response to the House's order, and if so, requesting that the translation be prioritized so that the agreements could be tabled in the House and distributed to the committee as soon as possible. The motion also provided that if the agreements had not yet been produced by the government, that the committee request that they be provided by the government to be vetted in accordance with the parameters set out in the House's motion, and that this committee review them in camera. On February 25th, 2021, the chair of this committee inquired about whether my office had received the vaccine agreements from the government, and I confirmed that we had not. The chair subsequently wrote to the clerk of the Privy Council requesting that the government provide the agreements to the committee. And finally, on June 4th, 2021, the Assistant Deputy Minister for Policy, Planning and Communication Branch for Public Service and Procurement Canada, Mr. James Stott, informed this committee that the government was providing its vaccine agreements after having examined the contracts, quote, under the strict requirements of the Access to Information Act, and consulted implicated companies as is required to ensure the appropriate safeguards of their information, and that the government had applied the applicable exemptions to protect third-party or personal information, as well as to avoid jeopardizing orders or compromising Canada's negotiating position, given the volatility of the marketplace. Sur ce qui termine cette.
So on this note, it will be a pleasure for me to answer all your questions. Thank you.
Thank you, Mr. Dufresne. We'll go now to Ms. Caroline Maynard, Information Commissioner of Canada. Ms. Maynard, if you please, 5 minutes, please.
Thank you, merci. Donc, comme vous le savez, je m'appelle Caroline Ménard.
As you know, my name is Caroline Ménard. I'm the Information Commissioner of Canada. Since this is my first appearance before your committee, I thought I would start with a very brief overview of my mandate.
Most of you, if not all of you, are familiar with the process of making access to information requests. The overall administration of the Access to Information Act falls under the authority of the Treasury Board Secretariat. This means TBS oversees the handling of the access to information requests within government institutions. My role is to investigate complaints relating to those requests, normally because the institution is late in responding or because requesters are not satisfied they have received all the information to which they are entitled. I also have the power to initiate complaints myself, and at times, when an institution appears to have chronic issues relating to access to information process, I can initiate a systemic investigation of that particular institution. In addition, I can participate in court proceedings when necessary. My office has done this on a number of occasions. En tant qu'agent du Parlement,
as an agent of Parliament, I report annually on my activities. Just last week, I tabled my annual report for 2020-2021. I can issue special reports to Parliament in respect of important issues that fall within my powers and functions. My most recent special report focused on the systemic investigation I conducted into Immigration, Refugees, and Citizenship Canada. In the past 12 months, I've also tabled special reports on systemic investigations conducted into the Department of National Defense and the RCMP.
Act, using the full range of tools and powers at my disposal. I understand that you are currently considering documents you received from PSPC, which contain redaction based on the principles of the Access to Information Act. However, these documents have not been requested pursuant to the Access to Information Act, but rather produced through motions adopted in the Chamber and in committee. Since my mandate does not encompass reviewing redactions to record produced in the context outside of the Access to Information regime, I have not been consulted, nor I have been involved in any way. As such, I cannot comment on the disclosure or redactions of these particular documents. It is worth noting that if these records were requested under the Act and I were to receive a complaint concerning their disclosure, I would undertake an investigation that would require that I afford parties a reasonable opportunity to make representations prior to reaching. I would also be precluded from commenting publicly on any investigation in progress. J'arrêterai ici pour répondre à vos questions si nous avons.
I'll stop there and am free to answer any questions.
Thank you, Ms. Maynard. We will start our questioning now with Ms. Rumpel-Garner, I believe. 6 minutes, please.
Thank you, Chair. My line of questions will be directed to Mr. Dufresne in trying to ascertain what the committee should do with regard to next steps in trying to obtain the documents that we have not received yet to date. So just for clarity, how many documents did you receive under the House order from October of last year, approximately?
We have received approximately 6,307 documents.
And those have all been released to the committee so far?
They have.
Okay.
And excuse me, there's some that have been received that have not been released to the committee because they have not been translated. So 6,307 have been tabled.
But not a million?
No.
Okay.
Pardon me, Ms. Rumpel-Garner, I've stopped your time. Your microphone is not connected properly.
It's going to be what it's going to be, Chair.
Maybe just unplug it and plug it in if you haven't done that. So make sure it's selected.
Sounds good here, Mr. Chair.
Well, it's the interpreters who have the deepest concern about this. So if we could just make sure that the sound is as good as we can make it for them, that would be good. So
it's always during my time. I'd just like to proceed if possible.
Okay, well, we are trying to look after the interpreters as well, but I will resume your time now. Go ahead, please.
Thank you, Chair. So, Mr. Dufresne, in terms of possible next options for recourse of the committee, I am looking at the matters which were disclosed this afternoon with regard to the fact that the government has apparently, the Attorney General has filed an application in federal court requesting an order to confirm or to seal documents related to the National Microbiology Lab and the transfer of Ebola. Are you aware of this filing from the Attorney General?
I am, yes.
How unusual is this?
Well, this from time to time there are proceedings in court, and the role of my office in these proceedings is to represent the interest of the institution, the Speaker, and defending the privileges of the House. And so that's been done by my predecessors. It's been done by myself.
Thank you. Has this ever happened before?
In the specific context in terms of an order to produce documents, to my knowledge, it has not.
Has the government taken the House to court over documents of this Parliament?
By this Parliament, no. This current Parliament, no.
Thank you. What about previous sessions of this Parliament? For example, the Speaker Spotlight documents.
To my knowledge, no. This is something that we can look into and confirm in terms of precedents. There have been precedents where privilege has been raised and determined in court.
My understanding is that Parliament is immune from judicial intervention. Is that correct?
It's in terms of a matter falling under parliamentary privilege. If a matter falls under parliamentary privilege, then the House will have exclusive authority, and that's the position that I will be taking.
Thank you. So can you assure that the members of the committee that the rights of Parliament will be defended against this court application from the government?
I can confirm that I've been instructed by the Speaker of the House of Commons to challenge the jurisdiction of the court in this matter.
Order.
Parliamentary privilege.
Point of order, Mr. Chair.
Pardon me, Mr. Van Bynen, on a point of order. Ms.
Yeah,
your time is up.
My point is with respect to relevance, Mr. Chair. the issue that we're discussing here is not relative to HESA.
I would argue that it is directly material, Chair, like directly related to the item at hand, but I understand.
Mr. Chair, how are the documents relative to the Canada-China
thank you, Chair.
Thank you, Mr. Van Bynen, and thank you all. We do allow a certain latitude. I'm certainly the question of admissibility of documents in the process, I think, is relevant. In any case, I will start Ms. Rempel-Garner's time again, and please carry on. And but do bear in mind relevance if you can.
I would argue it was directly relevant, but with that, I will be sharing my time with Mr. Davies.
Thank you. Mr. Davies, go ahead, 2.5 minutes.
Thank you. Mr. Dufresne, you on March 20th, 2020 sent a letter to the clerk of this committee in which you said this: the House's and its committees' powers to order the production of records is absolute and unfettered, as it constitutes a constitutional parliamentary privilege that supersedes statutory obligations. Do you stand by those words, Mr. Dufresne?
Absolutely.
Now, last week, Mr. Stewart, Ian Stewart, who's the head of the Public Health Agency of Canada, came to this committee and stated that he would refuse to turn over those documents that were ordered to this committee because he felt that he was bound by other statutes, that he worried that he would break the law of those other statutes if he complied. Is he correct or incorrect in that view in your assessment?
The view that I've shared with this committee and other committees is that the power of committees and the House to send for persons and papers is part of parliamentary privilege. It's a constitutional power and right, and it supersedes statutory provisions that would otherwise limit production of information. And so the House and committees have the authority, and in the situation where it is not done, then the committee can report the matter to the House, and the House can take the appropriate steps as it has.
Now, if a person refuses to comply with such an order, does that not violate the privilege of parliamentarians?
In the situation where a person does not provide the information sought by committees, the committees has a number of options. It can determine that the reasons put forward are valid. It can determine that it will find a compromise situation. It can determine that it rejects the position taken.
But Mr. Dufresne, in the event that the committee wants the documents and that's their determination, the question is straightforward. Does a person who still refuses to provide those documents in that circumstance, do they violate the privileges of that committee?
Well, they're in breach of the order of the committee. The committee can report it to the House, and then the House can make the findings in terms of the exercise of its privileges and disciplinary powers.
Thank you. Now, on October 26, 2020, the House of Commons passed a motion ordering the government to produce all documents related to various issues. I think you already commented on this order concerning various handling of the COVID crisis to this committee through you. Now, those documents were required to be delivered to the law clerk in unredacted form. The law clerk was to redact according to specific criteria contained in the order, and then to deliver those documents to the committee no later than December 7th, 2020. Has that motion been complied with by the government?
Well, we've received a number of documents. In some instances, some of the documents contained proposed redactions, which is consistent. In some situation, we have seen the vaccine agreements have been disclosed, and they contain redactions. So these are documents where I cannot see behind those redactions.
Thank you, Mr. Davies. We go now to Ms. O'Connell. Ms. O'Connell, please go ahead, 6 minutes.
Thank you, Mr. Chair. Thank you, Mr. Dufresne. My questions are for you as well, and I'm going to get right to it because I have limited time. So do you have a copy of the October 26, 2020 order in front of you?
I do.
Thank you. For the benefit of the committee, can you please highlight to me or tell me the specific section that refers to vaccine contracts?
I do not believe there is this specific reference to vaccine contracts. There is language about all documents relating to the COVID-19 vaccine task force and its subcommittee, and so it's a long order. It's a broad order, but I don't believe that vaccine contracts specifically is referred to.
Right, it's not. And so in terms of the vaccine task force, is the vaccine task force the signatory of the contract, or is it the Government of Canada?
Those are signed by the Government of Canada.
Right, so even discussions that is ordered in this motion in terms of the task force, that's one thing, but the contracts themselves are explicitly mentioned in this order. So I recognize there's broadness. However, as a parliamentarian, we vote based on, you know, the four walls of the paper, so to speak. So if vaccine contracts are not referred to in this, then how is a parliamentarian who voted on this motion to surmise what you may determine as broad? Or can we conclude that vaccine contracts are not part of this order?
Well, I think it's up to the committee to make the determination as to whether, and ultimately to the House if it's raised before the House, as to whether it's satisfied with compliance. That's an interpretation that's would be done by those bodies.
Fair enough. Fair enough. So I think, though, we can conclude vaccine contracts are not part of the October 26, 2020 motion.
They're not. It's not specifically cited.
Right. So then let's move to the motion of the committee, because you referred the committee can then make changes. So I keep referring to it, Mr. Barlow's committee motion. So let's refer to that, where it does in fact talk about vaccine contracts. However, if the first paragraph, if you have it in front of you.
I do.
Okay, perfect. That it refers to the law clerk and parliamentary council inquiring whether or not the contracts of the 7 vaccine agreements have been provided. However, as we just concluded, vaccine contracts were never part of the October 26 motion. So that first paragraph in my mind is void. You can't ask for something. You can't amend a motion by another motion in this manner without it being part of the House. So let's move to then the second paragraph talks about then if you as a law clerk have those documents, how you would move forward in providing them. But then let's get to that third paragraph, which I think is the important piece, because it's clear that you weren't provided those documents because it wasn't part of the October 26 order. So therefore, it goes to the third paragraph, which says if the law clerk does not have such documents, that the committee requests from the government the contracts for Canada's 7 vaccine agreements with suppliers, and it goes on. So if the contracts were never part of the October 26 motion, therefore they were not a requirement to be sent to you directly, then this motion, the Barlow motion, says that those contracts were requested, not ordered, but requested to be sent to the committee directly, which would allow the government to make the redactions because there was no requirement to send them to you directly. Is that accurate?
Well, I think, again, it depends on the interpretation that the committee or ultimately the House would give. So the first question is, are the vaccine contract agreements included as part of the? That's the first issue. And the second issue is in the second motion.
Sorry, I don't mean to interrupt. I'm just limited on time.
Sorry, yes.
So my question, though, is not about the committee. You're the witness, and it's your opinion that is being debated here. So if the vaccine contracts were never part of the October 26 motion, you're right, committees can at a later date make a determination, but they haven't done so. So we're just dealing with the 4 corners of these 2 motions. So if the committee has not taken any further action to date, it means the October 26 motion does not require vaccine contracts be sent to you. Therefore, the Barlow motion has a clause in there that the government can send the vaccine contracts directly to the committee, which would mean they would be responsible for the redactions because there's no requirement to send them to the law clerk.
Well, and again, I think it's up to the committee to interpret the Barlow motion in terms of the language that the documents be vetted in accordance with the parameters set out in the House motion. So it's really the interaction of those
Right,
two.
but then if you go back, sorry, I'm just limited on time. I don't mean to be rude, but if you go back, it refers back to the October 26th motion, which we've already determined doesn't refer to vaccine contracts. So you can't put in a clause in a motion about another motion where it doesn't exist. Therefore, the vetting process would be done by the government as per that third clause, which would mean the government's in complete compliance.
Again, all I can say is really it's for this committee to make those interpretations. You have an order of the House, you have an order of the committee,
Fair,
and the
but
order of
it's
the committee
not your
references.
interpretation. As of today, there is no motion before you that your interpretation that the vaccine contracts were not in the October 26th motion. Therefore, there was no requirement for those documents to be sent to you first to be vetted. As of today, if the committee changes their mind, that's their prerogative. But as of today, your position
Thank you, Ms. O'Connell.
The
witness may certainly answer, but Ms. O'Connell, your time's up.
Okay.
If the witness wishes to answer, please do so.
I just want to reiterate that it's up to the committee to interpret the reference in the House order to documents relating to the vaccine task force and how broad that would be, and then to interpret the Barlow motion that is making reference to the House order and the parameters for vetting.
Thank you.
Thank you. Nous allons maintenant à Monsieur Lemire, je pense. Monsieur Lemire.
Mr. Lemire, go ahead. 6 minutes. Thank you. First of all, I would like to change my time with Mr. Davies, if he would like, and I will continue afterwards.
Mr. Davies, go ahead.
That's fine. Mr. Dufresne, I'll just pick up where Ms. O'Connell picked up. Mr. Barlow's motion starts, I'll read it to you. It says, if the law clerk does not have such documents, that the committee requests from the government the contracts for Canada's 7 vaccine agreements. We'll stop there. Mr. Dufresne, why would you potentially have such documents or not, if not by virtue of the October 26th, 2021 order of the House? Was there any other order you're aware of that would have served as the ground for you having the vaccine contracts?
No.
And second, I'm going to read to you a passage from our federal procurement minister, Liberal Anita Anand. This is what she said on October 26th, 2021 in the House when speaking to the motion. She said, the difficulty with the current motion, and in particular, the very reason I am here today as Minister of Procurement, have been involved in and have led the signing of hundreds of contracts for PPE, for vaccines, and for rapid test kits for the benefit of Canadians' health and safety. And if this motion passes, it is my grave concern that those contracts are at risk. These negotiations are at risk. And suppliers will then, if the contracts are disclosed, as a result, be hesitant to contract with the federal government. And that I'll carry on. Mr. Dufresne, you would agree with me that clearly it was in Madame Anand's mind on October 26th that motion clearly contemplated the production of vaccine contracts. Would that be a fair interpretation of those remarks?
Well, I don't want to interpret the intentions. I think that the statement is there and stands for itself. And
it does. Sorry.
Well, and then the order of the House, I would just add, makes reference to the issue of the vaccine task force and tasks my office to consider if the disclosure could reasonably be expected to interfere with contractual or other negotiations. So there's language there as well referencing contractual negotiations.
Well, of course, and I'm not going to waste any more time on this because the position of Ms. O'Connell is so preposterous. Obviously, the vaccine contracts are at issue. They've always been at issue. I could just ask you this: has the government to this day ever told you that vaccine contracts are not subject to the October 26th, 2020 order? Have they ever taken that position?
I don't believe they have. No, it's no.
Now, how many documents have been delivered to your office of those millions of documents that Mr. Shugart told this committee the government had in its possession?
I think it was millions of pages. I think that was the reference, not millions of documents.
No, it was actually millions of documents, but
okay.
nevertheless,
Well,
pages, documents, but it was documents. But tell me, how many have you received?
So we received 8,500 documents.
Okay, so just be conservative, using that figure as a percentage of, say, 1 million documents conservatively. That means this committee has received less than 1% of the documents ordered in 7 months. Now, at that rate, it will mean it will take some 700 months or 58 years for the Liberals to comply with the order of the House. To the information officer, does that conform with your notion of transparent government in Canada?
Not to provide you with the information that they said that they were providing you. It's outside of my jurisdiction, but according to what we know about transparent government, if they are voluntarily providing information, that's being an open and transparent government.
Over 58 years?
Oh, you mean for the timelines?
Yeah.
Well, under my act, you have 30 days to provide information, or you can ask for an extension. And then if there's a complaint about the extension, I can make an investigation on that.
Okay. Now, back to you, Mr. Dufresne. Back to Mr. Barlow's motion, when he said that the vaccine agreements be vetted in accordance with the parameters set out in the House motion, would that be your interpretation that that means that the House motion's requirements that the vaccine contracts be vetted by you,
Well, the vetting in the House order is to be done by myself, by my office.
And the documents in the House order are to be sent you in unredacted form. Is that correct?
That's in order for me to vet. That has to be. I have to be able to see what the information is.
And the criteria, I think you've already specified the 3 criteria by which the documents will be vetted. Those are different than the criteria under the Access to Information Act, aren't they?
There's some similarities, but it's not a reference to the provisions of the Access to Information Act. These are the grounds that the House accepted.
Mm-hmm. Well, it's been a while since I looked, but I counted at least a dozen different criteria for redaction in the Access to Information Act, and the House order specifies 3. Is that correct?
That's correct. Correct. Yes.
So when James Stott, the Assistant Deputy of Public Services, delivered vaccine contracts not to you, but to the clerk of the Health Committee, are you aware that those documents came pre-redacted?
They did.
And they were not redacted by you, were they?
They were not redacted by me, no.
And he specifies in his letter that they were redacted according to the Access to Information Act, correct?
Yes.
Now, so would you agree with me that the government was not in compliance with the House order of October 26th when it delivered vaccine contracts?
Well, they've applied grounds in the Access to Information Act as opposed to the specific reference to the grounds in the House order, and I'm not able to see behind those redactions.
But you didn't redact them, sir, did you?
No, I did
not. And the House order says it's you that redacts, isn't it?
The House order says that they are to be vetted and implicitly redacted by my office on those bases, yes.
My final quick question, Mr. Chair. So if that's the case, obviously the government did not comply with House order, Mr. Dufresne. That is impossible to deny.
Well, point of order again, Mr. Chair.
Thank you, Mr. Davies. Your time is officially up. Mr. Van Bynen on a point of order.
Thank you. My point of order is that there's a reference to the House order, and the House order makes absolutely no reference onto how the contracts would be treated. The contracts are. My point is the contracts are.
This would be debate.
This is debate, I'm afraid. Thank you for your input.
That's not debate, that's desperation.
Mr. Davies, we're back to you. You have 6 minutes.
Well, I don't know how much clearer I can get. Let me go back then to you, Mr. Dufresne. I'm not trying to put you on the spot or make you uncomfortable, but I'm just trying to, I guess, prove that water is wet. If the House order says that all documents delivered have to be redacted by you, according to 3 criteria mentioned in the House order. And you did not redact the vaccine contracts. And those documents came pre-redacted by someone else who redacted according to criteria under the Access to Information Act. Is there any other logical conclusion other than that the government was in violation of the House order of October 26th?
Well, you have the House order saying documents are provided to my office, and I would vet them under those 3 grounds. You receive documents that are vetted by the government on different grounds. So the issue is whether the committee is satisfied with the grounds that are proposed by the government, namely the grounds in the Access to Information Act.
And thank you. Does the executive branch of government have the prerogative to withhold records duly ordered by the legislative branch?
Well, in my view, as part of the privileges of the House, power to send for powers and persons, it's up to the committee and ultimately the House to determine what grounds it will accept as a basis for redactions. And so the government, in my view, does not have the unilateral right to make those determinations. It's up to the committee and ultimately to the House.
I mean, isn't that a feature of just basic responsible government, Mr. Dufresne? If you had an executive branch that simply refused to provide documents when ordered to by the House, say on a budget, say on any other feature of government, if they just said, no, we have secret documents, we're not sending them to the House, it doesn't matter if the majority of the members of Parliament have demanded them, does that not strike at the very core of responsible government?
Well, I think what we've seen in Speaker's rulings, from Mr. Milliken's ruling and the more recent ruling of Mr. Speaker Rota, is the balancing and the mention of the House of Commons as the grand inquest of the nation, having these privileges to send for persons and papers, and the ability to make those determinations. At the same time, the executive has responsibility as defender of the realm, and there are valid reasons and valid considerations of public policy that ought to be considered, but ultimately it's for the House to make that determination.
Well, that's my question, sir, is when those two things collide, if the House is demanding production and the executive says no, who wins that battle in the end, Mr. Dufresne?
Well, ultimately the House has the ability to order and to make the determination, and then it has the disciplinary powers to act on it.
Now, you've already touched on this as well. The government consistently sends you documents that have not been translated into both official documents. Is that consistent with their obligation under the law?
Well, as I've indicated to the government and to this committee, in my view, the government has the obligation under the Official Languages Act to provide documents in both official languages.
So I guess, so let me just sum up here, if I may. You have a government that says that it has millions of pages of documents, in one case millions of documents, whatever, millions of pages at the very least. They have delivered 8,500, leaving at least 992,000 documents left to be disclosed. They have trickled the disclosure over 7 months. They refuse to translate them. They redact them when they're told by the House order that they're not to redact them. They use redaction criteria that are not specified. Forgive me if I might come to the conclusion that this is a government that is deliberately delaying the production of documents to the House of Commons. Is that a fair conclusion, Mr. Dufresne, for someone to draw?
Well, what I've reported to the committee on the situation and what I've received, and then it's up to the committee to make its determination as to whether it's satisfied with what has been produced and how.
Are there any statutory obligations that you can think of, whether the Criminal Code, the National Security Act, the Evidence Act, any statutes at all that you are familiar with in terms of parliamentary jurisprudence that would justify any member of government or public official refusing to produce documents to the House of Commons when demanded to do so?
There are no statutes that I'm aware of that have limited the privileges of the House to send for papers and persons. There are statutes that indicate public policy considerations, and Speaker's rulings have indicated these ought to be considered by the House, but it's up to the House. There has been no limit to the privileges of the House in terms of its abilities.
My final quick question. On October 26, 2020, Federal Procurement Minister Nita Nan told Canadians that the Office of the Law Clerk and Parliamentary Counsel, that's you, sir, wouldn't have the necessary expertise in procurement to properly redact records related to the production order. Tell me, sir, do you believe that your office has the necessary expertise to carry out the redaction instructions of the House of Commons?
We do, and in terms of information, factual information, certainly the government may be in possession of information, for instance, talking about impact on contractual negotiation. The government may well be in possession of the information, which is why the approach that we've taken is the government can propose to my office areas that it feels ought to be redacted and kept confidential, and certainly we consider those very, very carefully. And that's how we've approached it. In terms of any information factual that we would not have, the government or any party can provide it to us.
Thank you, sir. I think what we're seeing here is what you call a cover-up.
Thank you, Mr. Davies. So that ends round 1 of questions. We will start round 2 with the Conservatives. Would that be Ms. Rumpel-Garner?
Yes, thank you,
please
Chair.
Go ahead. 5 minutes.
I'm very interested in what my colleague, Mr. Davies, was alluding to with regard to building a case around cover-up and the responsibility of parliamentarians, and I would cede my time to him to allow him to keep questioning.
Thank you, Ms. Rumpel-Garner. Mr. Davies, apparently you're up again.
Well, thank you, Mr. Chair. Well, I'm going to continue on with that because it's easy to identify, and I think there's a few members of this committee that are old enough to remember Watergate in the United States. I certainly do. It's a little harder to recognize it when it's close to home. But Mr. Dufresne, when you have a government, I'm going to take you back to 2011 when Speaker Milliken ruled on something extremely similar to this. There was the House of Commons passed a motion ordering the then Harper Conservative government to produce documents to the House related to the Afghan detainee issue. When they refused, what was the finding of Mr. Milliken, sir?
So the finding was that this was a prima facie question of privilege, and Mr. Milliken dealt with the issue of a claim by the government of national security and found that at the end of the day, the House has the ability, as part of its privileges, to seek the information. That said, Speaker Milliken did say that there were important responsibilities on both sides, in the House and the government, and that both sides ought to try to work together to find a way that would allow the role of the House as the grand inquest of the nation and the role of the government as defender of the realm to be met. And that's what was asked, and that's what occurred in that case.
That's exactly right. I was just going to say that that's exactly what did happen. Is the response of the government then was not to resist production of documents and run off to federal court, but rather the Harper government sat down with the opposition and they worked out a compromise where those documents would be produced to a special committee that had certain parameters around it to examine the documents. Is that correct, sir?
Yes.
Has that been offered in this case by the current Trudeau government?
Well, I can only talk about the fact that proposed redactions have been made to some of the documents received, and so that's a determination that's been made by the government that I have not been able to see behind.
No, of course, in this case, what happened is the Trudeau government unilaterally decided, not with any negotiation with the opposition, but unilaterally decided to send those documents to NSICOP in one case, but they haven't done anything with respect to these health documents, have they? Have you heard, has the government proposed anything to you about how those 990,000 pages that remain at least might be handled?
Well, as I've indicated, the government has been in contact with me and with my office in terms of informing us we're going to be getting batches on a monthly basis, and so we are in communication. But the outstanding issue remains in terms of some of those redactions that we can't see behind.
Mr. Dufresne, when's the last time you received a batch of documents from this government?
I would have to verify this. I believe it's April as part of the regular batches of documents. That's my understanding.
Did you receive any documents in May?
Looking to Mr. Bédard to see if he can confirm whether we've received. We might have to get back later to you on that, or perhaps in writing, sir. I apologize.
I'm looking for my date. The last, my information is that the last batch of documents you received was in April, sir. Is that, could I be correct about that?
But that's my initial understanding, subject to confirmation.
Have you received any documents in June, sir?
I don't know.
Sorry, you don't know or no?
No.
Now, we know that the documents are allowed to be redacted for national security reasons, for privacy reasons, and then in the case of certain documents, for any interference with contractual relations. Mr. Dufresne, is it your understanding that there's 990,000 documents in the possession of the government that relate to national security or privacy concerns, and that's why they're withholding those documents to this committee?
I don't know what the government has in its possession that they have not given to me.
Mm-hmm. Have they withheld any of the documents that you've gotten? Have any of them related to national security or personal privacy, or engage those concerns?
I believe we have some proposed redactions in some documents that have not yet been translated that we will be looking at. And that would be with respect to personal information. And I believe that we also have a document redacted on the basis of government security under the Access to Information Act.
And did you do that redaction,
Davies? Thank you, Mr. Davies. I expect you'll have a chance to resume your questions later. We go now to Ms. O'Connell. Ms. O'Connell, please, 5 minutes.
Thank you, Mr. Chair. Mr. Davies, in a pretty rude comment to my colleague, Mr. Van Bynen, referred to his point of order as desperate, but watching that interaction by Mr. Davies was what I would determine as pretty desperate, referring to something as Watergate, a cover-up, withholding documents. Pretty interesting, given the fact that thousands of documents have been handed over, that these unredacted documents have been handed over. Documents have been handed to multiple committees. Grasping at straws might be another characterization, but it's okay. We'll continue in the witch hunt of the Conservative NDP coalition that I never thought I'd live to see the day, but here we are. So, Mr. Dufresne, I apologize. My questions are no way. I feel for you in this very clearly political battle here, but I just wanted to clarify a few things that I heard in the last kind of round of questioning. Have you has it been indicated by the government that they are withholding any documents? That's a pretty big accusation, because you indicated there are thousands of pages and they are coming in and they are still coming in. Has there been anything that has come to your attention that the government has said, we are withholding these documents?
Not to my knowledge. No, as I said, we have some documents with redactions that we can't see behind. Fair, and we continue to expect the disclosure to come to us when it comes.
Right, because this is a process that's ongoing. So there is no withholding. And I think this type of language is consistent with, again, that kind of theme of desperation to, there is no conspiracy theory too small that the Conservatives and now the NDP won't track down. So I want to get into, again, another point of clarification. Again, if I'm referring back to, I keep referring to it as the Barlow motion, but the motion from February 5th, again, in that third paragraph, Mr. Davies kept referring to, in reference to this motion, the documents were, that the documents were ordered by the House. This motion says that the committee requests the government, the contracts. Is this an order of production of documents?
Well, the motion of the committee is a motion that was adopted by the committee.
For a request. That's the language, correct?
It's a motion that requests from the government the contract.
Right. So, which, again, the government did provide to the committee as set out in that third paragraph. I feel for you, Mr. Dufresne, because I feel that when it comes to the production of document motion, the original in October, I feel that what had happened was it was a poorly written motion, left out a pretty big piece in terms of vaccine contracts that the Conservatives seem to think that they want to have at all costs, even if it puts vaccines in jeopardy. And so instead of dealing with the fact that they wrote a pretty poor motion, they then come back and try to come up with a motion, which I refer to as the Barlow motion, and try to like put in a clause that suggests that vaccine contracts were included in the original October motion, but you can't make something exist that doesn't exist that Parliament has already voted on. And we've heard all week that Parliament is supreme, and Parliament voted on that October 26th motion that did not include vaccine contracts. So then the Barlow motion came forward and the government complied with it. So moving on to the redaction piece, I wanted to just, again, if we're referring to the Barlow motion, since there is no reference to vaccine contracts in the October motion from the House, then my question is in and around the redaction or the vetting, because Mr. Davies rose in the House on December 3rd and actually, quote, said, "Nobody is asking for detailed commercial information," end quote. So when it comes to vaccine contracts and the vetting, even members of the opposition stated that they didn't want commercial information. So is that the vetting process that the government would have done in compliance with the Barlow motion on February 5th?
I think, again, it's up to the committee to determine whether it is satisfied with the production in light of the Barlow motion and in light of the House order that's referenced in terms of the vetting in accordance with the parameters set out in the House motion. So it really, again, for the committee to consider what it has received, why certain things may be redacted, and whether it's satisfied with those reasons.
Fair enough.
Thank you, Ms. O'Connell.
Whether or not they're trying to rewrite history with a couple of bad motions that didn't really cover everything.
Thank you, Ms. O'Connell. We go now to Ms. Rempel-Garner. Go ahead, please, 5 minutes.
Thank you, Chair. I'll just start by saying that the term witch hunt is pejorative to practicing pagans and Wiccans in Canada, and should be used with that understanding. And with that, I will turn my time over to Mr. Davies.
Very well. Go ahead, Mr. Davies.
Well, thank you. Well, again, I don't know how much more time we need to spend on Ms. O'Connell's attempt to try to pretend that today is Sunday when it's simply not. The quote that Ms. O'Connell raised was me speaking in the House, speaking to the commercial interests that would be at risk upon disclosure of the vaccine contracts. And of course, I was speaking in terms of the October 26th motion we were debating it, which along with Minister Anand's remarks, which I've already read into the record, make it crystal clear that everybody in the House and in the world understood that vaccine contracts would be covered by the October 26th order. So despite the valiant but weak attempt to try to pretend that's not the case today, that's not going to fool anybody. But I'll just come back to one part of this, Mr. Dufresne, and that is a straightforward question. When the vaccine contracts were delivered, and this government did deliver them, were they redacted in accordance with the instructions of the House order? In fact, I want to put the exact wording to you so that we can be very precise about this. Mr. Barlow's motion said that the documents be vetted in accordance with the parameters set out in the House motion. Now, I'll break that down. The House motion being referred to is the House motion of October 26th. Was that your understanding, Mr. Dufresne?
Yes, it is.
Yeah. Were those documents, the vaccine contract documents, were they vetted in accordance with the parameters set out in the House motion? What is your opinion on that?
Well, I was not able to vet them fully because they already are redacted. and they are redacted on the grounds in the Access to the Information Act, which are different from the grounds in the order.
Thank you. Madam Maynard, on June 15th, the Office of the Information Commissioner released its 2021 annual report, which documented a, quote, your words, culture of complacency, end quote, within the federal government. I'm going to quote from that. It's characterized by the view that responding to access requests is a distraction from employees' day jobs, rather than what it actually is, a core part of their responsibility as public servants to facilitate transparency in government operations, end quote. Madame Maynard, is it your view that that's a fair characterization of the attitude towards disclosure in the current government?
I'm talking about the public servants jobs, how it's their responsibility, and it is our leaders that need to make sure that they understand that's their responsibility to participate in the full process. Like I said earlier, people have 30 days to respond to access requests. In that 30 days, they have to process the information, they have to find it, they have to redact it, they have to disclose it. So if the person who has the information in their office refuse to give it to the ATIP office, that will definitely leads to delay, which we've seen in the last 6 years. The increase in times of responding keeps going up.
So you're saying that in the last 6 years, since 2015, the length of time it takes for the government to respond to access to information, that has lengthened?
Well, in the last 6 years, what I was going to say is that the number of access requests has increased by 225%, but the units that are responding to those access requests have not increased in proportional to the number of access requests. So definitely, we've seen more and more delays and more time spent.
Back to Mr. Dufresne. Let's compare apples to apples. So approximately how many pages has the government disclosed to you pursuant to the order of October 26, 2020?
So we've received, as I indicated earlier, about 8,500 documents, and I don't have the breakdown in terms of the number of pages. I will try to get that and provide that as soon as possible.
Okay. And in Mr. Shugart's letter on November 27th, the clerk of the Privy Council, Mr. Shugart, wrote to this committee with respect to that document production order, and he said this: preliminary estimates suggest that there are millions of pages of relevant documents. By the way, I think later on he clarified that there's a million documents as well, but that's where the confusion comes. But certainly in that letter, he talked about millions of pages of relevant documents. Would you agree with me, sir, that in 7 months, that the government has turned over a small fraction of the millions of pages of relevant documents that the government claimed in writing that they had in their possession?
Well, I would agree that we've certainly received much less than what was expected.
Thank you, Mr. Davies. We go now, I think, back to Ms. O'Connell. Ms. O'Connell, please go ahead, 5 minutes.
Thank you, Mr. Chair. Thank you, Mr. Dufresne. Again, I feel like we're going in circles. Mr. Davies, rest assured, I fully know it's not Sunday. I simply understand the games and the coalition by the Conservatives and the NDP in this attempt to rewrite motions and reposition the House's ultimate decision. Mr. Dufresne, I appreciate that you continue to repeat that ultimately is up to the determination of the House or the committee to determine, the procedure of motions. So I appreciate that. I hear you on that, and I again feel for you that I think the opposition is trying to have you say something otherwise and take away their responsibility from having to do the work and fulfill their own kind of mistakes in their motion. So I want to get back to, because I can't seem to get off this point about the two motions. Mr. Davies continually refers to somehow that, again, referring to vaccine contracts, that somehow these documents it did not comply with the House motion. However, as we've stated and indicated very clearly, there is no section within the October House motion that actually refers to vaccine contracts. The first time that shows up is in the Barlow motion of February 5th. And in that motion, it says, if, again, I already read into the record that if the law clerk does not have such documents, we've already been down that road in terms of why you wouldn't, because it was never required in the original October motion. And then it talks about that the committee requests from the government the contracts of the 7 vaccine agreements with suppliers be tabled with the committee in both official languages. Was that done, to your knowledge, Mr. Dufresne?
To my knowledge, that was done, yes.
Okay. Then it says that the documents be vetted in accordance with the parameters set out in the House motion. Now, this is the question, because these documents are not referred to in the House motion. So would it be fair to say that, because you mentioned also that they were done in the frame of the access to information. So if the government is handed a poorly written motion that doesn't have, you know, it talks about the parameters in the House motion, but the House motion doesn't actually refer to these documents, is it not a reasonable thing that the government would then turn to the Access to Information Act, which is a standard that they would use in terms of the vetting process? I don't know if Ms. Maynard would like to answer that, and Mr. Dufresne, but if the motion is inaccurate, is it not reasonable that the government would then use the parameters in legislation that is commonly used for the vetting of documents?
Well, my view, the committee could do that if it's so stated in its decision. My view, the committee decides, and ultimately the House decides what grounds it will accept. And so in this instance, the House has agreed to certain grounds in the order. The motion talks about vetting in accordance with the parameters set out in the motion. And so it appears to relate to those parameters, which would be the personal information, personal privacy, national security, and the commercial matters. But ultimately, that's for this committee to decide.
Right, but if the government has indicated that that's precisely what they did, there was no requirement, actually, given the Barlow motion on February 5th, there was actually no requirement for them to provide those documents to you, or else the third paragraph wouldn't exist at all. So then if they followed the parameters of the House motion, then they've met the terms of the motion. There is nothing in this motion. Would you say it's fair to say that there's nothing in this motion that says, you know, basically that there's an arbiter of the parameters? The parameters were set in the House motion. This clearly sets out that you don't have to receive them in advance, or else why would there be a clause taking that into account? So if the government says they did the proper redactions based on that, then they've complied with the motion.
Well, I think I understand the proposition you're putting forward. I think ultimately it's for the committee to decide whether that's the interpretation that it will take. From my office's standpoint, I am vetting the documents that I received on the basis of the House language in the House order.
And then these documents are being vetted in accordance with the Barlow motion. Thank you.
Thank you, Mr. Connell. We go now to Monsieur Lemire. Monsieur Lemire, allez-y, s'il vous plaît, 2 minutes et demi.
Mr. Lemieux, 2.5 minutes. Thank you, Mr. Chair. Since my question is for Mr. Dufresne, since the committee can, we see that the House of Commons has reprimand powers. You say that the committee has 3 options. The first is to accept the modifications, and here we're talking about an issue of transparency and public interest, and it's too bad the government doesn't understand. To compromise would be possible, but could you tell us if in such a case, well, what are you advising us to do? How can we receive a transparent answer on behalf of the government? What I said in my letter to the committee, I was asking for instructions ultimately, and it was on this issue of translation, because the government takes a position that it has to be done by my office and at Boy, and I believe that, and so I was asking for instructions if the committee wanted to give us the mandate to do this, given the circumstances, but we don't do this anymore, given it's the responsibility of the government. So we were waiting for instructions, and also with regards to disclosure, and if the committee was not satisfied in the way that a disclosure was being done, or the motives put forth for redacting, the committee cannot change the order of the House. Only the House can do that, but the committee can report on its satisfaction or non-satisfaction. In a letter that you sent to the Committee of Finance, you mentioned that the power of the Parliament to require documents is absolute, including. So parliamentarians have to take into account the public good. So sincerely, 9 billion in vaccines. Do you think that that has something to do with the public interest? Our country will paid a lot more than other countries. So how could we formulate a request that would be in the interest of the public to have access to this information? Did we pay too much for our doses, especially last December? How much should we pay? How much did we pay for this marketing campaign of Justin Trudeau for 240,000 doses? We knew that we were extremely late. I think that with regards to committees, it's always necessary to want to ask, what is your mandate? What is being studied? Why is this in the public interest to have this information to call the government to account? What information do you need? And then what are the reasons? Whether it be the government or a private company or an individual, there can be acceptable reasons. But also there are options. Sometimes it's to say this will be seen only by parliamentarians in camera. The information will not be mentioned in a report, but the parliamentarians can look at it. And some people had security issues. If we look at the case of in cases in the past, and we've always said we cannot ignore these considerations when they're reflected in acts or a public good, public interest, but it's up to the House. It's up to the House to have the last word. In the context of these procedures, it's up to the court in the context of issues involving citizens. Thank you.
Monsieur le Président, vous êtes
You're
sur,
muted there, buddy.
Sinon, je peux continuer.
Can I continue?
Thank you. Merci, Monsieur le Maire. We go now back to Mr. Davies. Mr. Davies, go ahead, 2.5 minutes.
Thank you, Mr. Dufresne. Back to Mr. Barlow's motion to get the vaccine contracts committee. The opening words say, if the law clerk does not have such documents, that the committee requests from the government the contracts for Canada's 7 vaccine agreements. Sir, can you tell us, committee, whether there would be any reason for you to have the vaccine contracts other than the October 26, 2020 motion of the House?
There would be no order that I'm aware of that would require the government to provide me with this information. It would be up to the government to provide them on its own initiative, but there'd be no order that I'm aware of that would require it.
Thank you, sir. That's because there isn't one. Can you give me a general idea, Mr. Dufresne, what the average number of pages per document is? Just the roughest ballpark estimate, the best you can estimate.
I'll turn to Mr. Bedard to see if he can provide that type of estimate in terms of number of pages per document. I think it varies, but I'll.
If in response to the question, if we were to talk about an average, that would be 5 or 6 pages. But this is not representative because we will have a document with only 1 page and other documents with 100 pages.
No, I understand, sir. That's why I'm asking for an average, and nothing I'm going to hold you to. I realize you're just giving me your best estimate, but let's just say it's 6. You've said you've received about how many documents?
we've received about 8,500 documents.
Okay, so my math is bad. I'm just do a quick thing. That to me comes to about 50,000 pages. 6 times 8,500, 51,000 pages. Now the government, of course, Mr. Sugar, the clerk of the Privy Council, has told us in writing that the government has millions of pages. Is your receipt of about 51,000 pages out of millions of pages of documents, does that in 7 months, does that strike you as an acceptable rate of delivery of documents in compliance with the House Order of October 26th, which, by the way, I will note for the record again, had a deadline of December 7th to produce documents?
Well, what I can say is there were estimates that were made by the clerk of the Privy Council at that time in those letters and in committee, and it was of a far greater number than what we have received so far. And I can't comment or speculate on the reason for that. I can only note that the initial estimate was much higher than ultimately the numbers that we've received.
And can you tell me just briefly what kind of
Thank you, Mr. Davies. Thank you. That ends round 2 of our questions. We start round 3, and we start with the Conservatives once again. Ms. Rimple-Garner, is it you?
Yes, it's me. Thank you, Chair.
Go ahead, please. 5 minutes.
I think we've heard quite a bit today. I think Mr. Davies' line of questions has established the obligations of the government under both the House Order and the Order of the Health Committee. Mr. Dufresne, thank you for all of your work in this regard. And thank you for your ongoing efforts to provide transparency to Parliament. It's been disappointing to not be able to have access to some of these documents, given the gravity of the situation. I would be remiss if I didn't say I kind of feel like we should talk about Britney Spears and her conservatorship today, and I feel like I should just say free Britney on the record. But given that, and given the amount of testimony that we've heard today, I'm fairly confident in what needs to be done next. And therefore, I move that the analyst and clerk be directed to prepare a brief report to the House outlining the material facts of possible contempt as discussed with Bill Matthews, Deputy Minister of Public Works and Government Services, concerning the documents ordered by the House on October 26, 2020, and further requested by this committee on February 19, 2021, and the report be tabled as soon as it's ready. Chair, it's very clear to me that the government is in contempt of both the House motion and the motion in front of this committee. Mr. Davies has, I believe, provided a masterwork to this committee in terms of laying out the obligations of the government that they have failed to comply with. Certainly, the government's parliamentary secretary has not responded in any factual way that would provide a case otherwise, and that's disappointing. But Parliament is supreme. And you know, the questions that have been raised by all opposition members today really show that regardless of political stripe, Parliament is supreme, and we have a right to this information. And when the House or the committee orders this information, it's not up to the government to try and sue the Speaker of the House of Commons or to try and obfuscate. Sunshine is the best disinfectant, and if there's no problem, then there should be no issue providing these documents to us. If there are problems, then it is up to Parliament and to this committee to consider best ways forward. So certainly I look forward to the clerk and the analyst providing this report. And I look forward to ensuring that Canadians, regardless of how they vote, know that Parliament functions. And whatever flavor of government is in office, but certainly this Liberal government right now, understands that their power is limited by each of us, that we don't report to the government, that we hold them to account. That is our role here. And to the Liberal members on this committee, including the Parliamentary Secretary, your role is to hold the government to account. It is to ensure that every action is happening in the best interest of Canadians, not to toe the party line, not to cast aspersions, but to ensure that transparency is provided, that accountability is provided, and good and just government is provided. What we have seen from this government on the obfuscation and delay of governments is an affront to Parliament, and it's an affront to democracy. We might not agree on policy and we might not agree on political stripe, but we should agree that Parliament is supreme. And we should agree that our rights as parliamentarians are paramount. The work of Mr. Dufresne and the Law Council, I know you've tried to do your best, the Information Commissioner, the Privacy Commissioner. I strongly feel this. This isn't, what has happened over the last several months in Parliament is very concerning to me and many people. Of course, there might be times when the government might not want certain facts to come to light. That is true of any stripe of government, but we cannot ignore the fact that Parliament is supreme, that we have the right to look at these documents, to ascertain what happened, to pass orders for productions of documents, and then provide a better path forward where we see deficiencies. There are ways to put constraints around the release of documents. For example, Mr. Barlow's motion talked about reviewing things in camera. These are sort of deliberations and bounds that can be put on release of information. But that's not what this government did. And that's certainly what Mr. Davies exposed with his line of questions today. There was no effort to work with Parliament. There was no effort to work with the opposition. It was a borderline dictatorship move. And that's enough. Enough of that. We don't want that. So this motion is important because, and I hope every member on this committee agrees, that we are supreme and we have an accountability to our constituents. I hope it passes, and I hope that light is shed on these matters. And again, in my closing words to you in this Parliament, I would just go to Mr. Dufresne. You have a big job ahead of you in coming days. And I want to say to you, on behalf of the 120,000 plus constituents that I represent, they're depending on you to make a case for our place of democracy. We cannot allow what has happened to continue. And as Parliament adjourns for the summer, we look to you now to ensure that the torch is bared and to ensure that we're not silenced by rulings that preclude our supremacy. So thank you, Chair. And I now pass it over to the rest of my colleagues, hopefully in support of this motion.
Thank you, Ms. Rimple-Garner. You did move the motion, I believe, and then followed up with an argument. So we'll take a motion as moved. It is in order. I have Mr. Maguire next. Go ahead, Mr. Maguire.
Thank you, Mr. Chair. I just wanted to congratulate my colleague. I do support the motion that she has put forward. You know, we really do need to get to the bottom of this process. We've heard a lot of confiscations today. In regards to cover up of material. You know, we've only seen 8,000 pages or documents, I believe, has been very clearly stated by you, Mr. Dufresne, and we really appreciate your testimony today as well. I think it really clarifies it for Canadians as we, for any that are listening or maybe picking up on this. As Parliament ends this session, the government is still not providing information on the table for Canadians to know what's going on, or even for us as committee members. And even though Parliament is supreme in this case, and that we really need to get to the bottom of it to find more information. It was very, very clear that the contracts are what was at the base of this whole discussion right back from last fall. And you know, that when we're looking at trying to outlining the material facts of the possible contempt that was discussed with Mr. Matthews, the Deputy Minister of Finance and Public Works and Government Services, concerning these documents ordered by the House on October 26th last fall, we really do need to get a report tabled as soon as we possibly can. And I think that the timing of trying to, you know, we asked for the Privy Council to be here today as well, and I mean they aren't here, so why not? Others have made an attempt to be here. They've even had other, you know, extra time. We've had an extra couple of days here because this was supposed to have happened on Monday, and so there's no reason why we couldn't have had people show up on the very last day of Parliament to sitting for the summer to be able to provide the information that's required to get to the bottom of the cover-up that the government has had in regards to not wanting to discuss any of the information in regards to the contracts. And I think that's one of the biggest. That is the biggest reason that we've had, Mr. Chair, and I think that it's very clear that you know, we're getting to the bottom of the matter is not what the Liberals want to do.
Pardon me, Mr. Maguire. Ms. O'Connell on a point of order.
Thanks, Mr. Chair. Since we're into debate on a motion, I think it would be fair to allow the witnesses to go. I don't think they need to listen to the Conservative spin after they've already confirmed that this is not a breach. But anyways, I think it'd be fair. The witnesses are honorable public servants who have done great work, and I appreciate their openness to these questions here today. And so I think it'd be fair to release them while we let the Conservatives drone on with their misinformation and conspiracy theories. Thanks.
Thank you, Ms. O'Connell. And I would ask the committee if they are in agreement to release the witnesses at this time. Is there anyone who opposes? Seeing none, I will thank the witnesses very sincerely for your time today and all of your efforts on an ongoing basis to assist this committee and the House. And with that, I would certainly invite you to leave if it is your will. And we will carry on with Mr. McGuire. Mr. McGuire, I apologize. We interrupted you. Go ahead.
Well, thank you, Mr. Chair. I certainly feel that the witnesses have done their job today because they've answered so many questions that we have to the bottom at for months in regards to this whole issue of cover-up and the lack of information that the government has had around our health committee for these months. This has been a situation where we've been trying to get to the bottom to find out why we were so late in getting vaccines in Canada, to get the information out of those contracts that would have given people the confidence to know that we could have been on the same basis as other countries that have been vaccinated for 3 months earlier than we were, and many of them have not had the same third wave levels hitting their countries as we've had in this country, and that's part of the reason why we're still locked down when we're going into July here, Mr. Speaker. Or Mr. Chair, pardon me. So I just want to say that I believe that this is a very valid motion. We want to be able to make sure that we get to the bottom, get a report on this contempt, and I don't know what other word to use there, because it's just been a confiscation of responsibility as far as I'm concerned in regards to making sure that Canadians were well informed on this issue. Never mind the fact that even we in the committee didn't get these documents even in any kind of confidence here either. And there's been, my colleague, Mr. Davies, has made an extremely sound case today for the whole very good history of what we've just gone through here to bring us to today. And yet we've still got a government that has some 900,000 pages of information that we haven't received. So I will leave it at that, Mr. Chair, but I really do think it's a responsibility of the committee to vote this motion in and try to get that report as quickly as we can so that Canadians can be assured of that everything was above board when we know full well that there were many holes in that package. Thank you.
Thank you, Mr. McGuire. We go now to Mr. Lawrence. Mr. Lawrence, go ahead, please.
Thank you very much, and I believe that our whole committee is indebted to the excellent work of Mr. Davies, who explained it in extremely explicit terms, but I will reiterate it probably not as eloquently as Mr. Davies has done. This is the call for the vaccination contracts is fairly simple. There is a House motion that calls for documents that says that should be redacted. It says explicitly that it's to be redacted by the clerk and not by the government or any part of the government. There is then Mr. Barlow's motion, which calls for those documents to be redacted in accordance with those motions. This is dead simple. This is not simple. This is not difficult to understand. And in fact, the government is blatantly disagreeing with this. And you know what? Yes, it's parliamentary supremacy. And that's clear. As Ms. O'Connell said, we've heard it over and over again from the Speaker of the House, from the previous Speaker of the House, from Liberals, from Conservatives, from NDP members. It is beyond doubt. We've heard it from the law clerk that Parliament is supreme. But that's not really the critical part of this, because we are to be governed by the people. And Parliament is merely a function of the people. And so when this government decides to blatantly and blazingly disobey the parliament, they are saying to every one of my 100,000 plus constituents, we don't care, we're going to do what we want, we are unresponsible. This is the height of irresponsible government. This is why our country was founded. This is the reason for the Magna Carta. This is the reason why we formed a responsible government. If the executive is not going to listen to committee, why do we even exist? Why is this committee here? If we have no power, if we have no authority over the bureaucracy, why we're just wasting money. We're just in a dining club. We are not a function of the people, which is who we are supposed to be. So when Ms. O'Connell, you call into question parliamentary supremacy, you are calling into question the very foundation of our country, of our nation, which I believe is the greatest country in the world. It is absolutely incumbent on all of us. And I say this not just to my colleagues in the NDP or my fellow conservatives, I say this to my Liberal members. You are the stewards of democracy, the stewards of responsible democracy. If you don't vote for this, you are literally disregarding all of that. All the men and women who sacrificed their lives so that we could have a responsible government, so that we could have a government that responds when people's voices are heard. We are saying, you know what, the law clerk doesn't get to see those documents. There are all sorts of provisions that are there to protect national security. And so whether it be Member Barlow or Member Rempel Gardner, they have used that power with precision. They haven't said, let's go ahead and have these documents all go out to the public. They're aware of the impact of this power, of the ability of the unfettered, absolute power to require any document, any witness from the civil service at any time. And so what they've done is they've protected our national security. They have protected the ability of any type of privacy by giving it to the law clerk first, who is a creature of parliament, and giving them the ability to censor it so that we make sure that no unnecessary documents. And then on top of that, they even go the next level and they say, well, we'll have the committee in camera. And so that we don't inadvertently allow some information, some privacy or other documents. But in conclusion, the law is absolutely clear. It is absolutely clear. We as parliamentarians have the unfettered, absolute power to have any documents we want when we want them. And we have asked for them. The government has disregarded that. This is not just a slap in the face to Parliament. It is a slap in the face to every one of the 37 million plus Canadians who send us here to Ottawa, who we are their representatives to. And shame on you if you don't vote for this motion. Thank you.
Thank you, Mr. Lawrence. We'll go now to Mr. Dantonneau. Go ahead, sir.
Thank you very much, Mr. Chair. Why is it so hard to get information from Liberal governments? I spent 10 years in opposition in Nova Scotia. Same problem. Liberal government who thinks, their arrogance thinks that they are the holders of everything. Who cares about the opposition? Who cares about Canadians? We're doing the right thing for you. And here I come to this parliament where the rules and traditions are greater. And what do I find? I see it's worse. I see it's worse. With all due respect to my Nova Scotia member on this committee, and you know, Mr. Kellaway, and with all due respect to you, because Nova Scotians tend to take care of themselves. But when I see this blatant disregard for the rule of Parliament, the simple request for Canadians to be able to see the contracts and how the decision-making has been done by this government, and the total disregard for it, sickens me. It sickens me to see the total disregard. You know, I had high hopes of being on the health committee where we could find out about issues, that we could talk about things that are important to my constituents, that we could actually talk about health issues. You know, to Member Sidhu, who's here, I'm very happy that I that she brought in her diabetes bill. I'm so proud that she was able to pass it unanimously in our House of Commons. That's how working together actually works. And my hats are off to you. But what I see here is this blatant disregard, especially by the PS, to come up with this false narrative. Oh, no, well, it's because of how the motion was written. Oh, come on. The government does not want to release these documents, and they are hell-bent in trying to hide it. Why? Let's get a report done. Let's be parliamentarians and uphold the law and represent the people that put us here and support the release of these documents. My final point would be this. Because of this disarray by government and this arrogance, I will call it, it's not our fault. They're the keepers of the government, but it's not our fault. Ms. O'Connell likes to bring up the Conservatives, and we use Mr. Lamoureux's line, the unholy group of Conservatives and NDP, and that's what Lamoureux is starting to use these days. But it's not our fault. It's the province's fault. It's Conservatives' fault. It's the manufacturer's fault. It's everybody's fault but the government. They should be ashamed. They should support this motion. We need to get down to the information. It's enough of this masquerade. Had enough. Thank you, Mr. Chair.
Thank you, Mr. Dantemont. Nous allons maintenant, Monsieur Lemieux. Monsieur Lemieux, allez-y, s'il vous plaît.
Merci, Monsieur le Président.
Thank you. First of all, because it's a national holiday in Quebec and festivities have started, I'd like to wish a good fête nationale to all the Quebecers here today. Well, there's not that many, but still we're interested in issues such as the CHSLDs. But this is not what we're talking about. Today we're talking about the hierarchy of law. Does constitutional law have precedence over legislative law? And why are people opposing the parliamentary prerogative with regards to personal information? And I'm perplexed. And I'm also referring to Section 18 of the Constitution that says that privileges and powers exercised by the Senate, the House of Commons, and members also will be prescribed by the Parliament of Canada. So Mr. Lemire is quoting the Constitution of Canada and reading it. And also, if we look at Section 1.8 and 1.8a, that speaks to the powers of standing committees and stipulates that standing committees can study or review all issues referred to the House and make report on the subject. But when the House says something else, well, they have to call witnesses and also produce reports. And to delegate to subcommittees a part of the authority. And so these are elements that I found interesting. I found interesting given the circumstances, Mr. Chair, especially in the study that we would have before us, because for me it's a question of national interest to try to see how much Canadians are paying for vaccines. We're talking about supply and demand. This is a world issue. We know that in the beginning, Canada had no vaccine production capability. We were completely dependent on the international situation. If we look at the price variance, if you bought a vaccine in December and if you buy a vaccine this summer, is it the same price? Did it cost more in the beginning because the government wanted to produce a show? What we know is that $9 billion would have been spent for vaccines. And so if we can compare supply and demand, can we have more elements to know what actually has happened? This is in the public interest. If I think it's really interesting when we look at these redacted documents on February the 5th. Apparently, Canada would have paid a premium, and I asked the question. I asked the question in a committee. I asked it of Mr. To the chair of Pfizer Canada, and I tried to see if the supply and demand should have something to do with the price. And he said that this had nothing to do with the decision in pricing. And so then I asked if the vaccine purchased by Canada or another country in December, would it be at a higher or lower price? It was purchased in the summer of 2021. Mr. Pinault said, I appreciate the question, but we won't publicly deal with the pricing. And so really, this is a situation where parliamentary privilege and the interest of the public is to find out how much did COVID cost. We don't have any answers, and I think it's absolutely fundamental to have this information. According to a preliminary analysis, it is estimated that vaccine importations totaled 16 million in December. Is that figure correct or not? This is from the federal agency. We found this for December 2020, so can we find out more? Ottawa had received 424,150 doses of Pfizer and Moderna at the time. Did the government refuse to say how much they had paid for these doses? Statistics Canada provides some clues, but it was nice on TV at the time to see elderly people receiving first doses of vaccines. And so what we see is that the EU paid a lot less than Canada for these doses, $22 for Moderna and $18.47 for Pfizer, according to Belgian figures. And the US spent $24 and then $35 according to data produced. So Europeans and Americans, two producing countries, well, in Canada, why we abandoned our ability to produce vaccine. And so maybe they're trying to do something symbolic to have vaccine production eventually, but Americans and Europeans receive more doses than Canada. They have production capability. These are two factors that have an influence on price. And I would like to know as a taxpayer, have we been able to receive a fair price for vaccines? And will the government see that this is a world economy? We are dependent on other producing companies. And now, this is another phase that we enter, and now we are completely dependent on the prices set by other countries. Can we do something? Transparency, not having redacted documents. It is urgent to have all these information to make enlightened decision. And my personal hypothesis is that we paid much too much, and pharmaceutical companies got rich on the backs of Canadian taxpayers. Of course, it's a pandemic. And money is all relative, but for me, there should have been responsible management, and this was not done, and it's urgent to make sure that researchers can use fundamental science, can do research to fund the entire chain of vaccination. As Mr. Lamotte was saying last week before the committee, there are many elements where we missed the boat. And maybe this is the question. The extra money that we paid in vaccination, could we have invested that in producing vaccines domestically? And I think that we might not get an answer. I'm not a scientist. I'm a parliamentarian, and I would like to have concrete data to be able to have these elements in mind. And the government is not providing us with this. It seems that it would be irresponsible to campaign on something so fundamental. Did we pay too much for our vaccine program? Thank you.
Donc, en ce sens-là, évidemment, j'appuie la motion.
So I support the motion.
We go now to Mr. Morantz, please. Go ahead.
Thank you very much, Mr. Chair, and I want to thank the committee for having me today. It's been a very, very interesting meeting. First off, I want to say to you, Mr. Chair, regarding the initial comments of the parliamentary secretary, I do not drone and I do not engage in conspiracy theories. When I say something, I mean it. Now, it's clear that transparency is paramount to the proper functioning of democracy in Parliament. If the government were really sincere about their claims of national security, they would have engaged in meaningful conversations with all opposition parties to come out with a way to have these documents be provided. But that simply has not been the case. It's hard to draw any other conclusion that there are problems in these documents that the government does not want to be made public. Now, it's important that as parliamentarians we work together, and that's not what's happening here. It's time to stop suing the speaker. That's just sheer desperation on the part of the government. But I want to turn to the excellent cross-examination of Mr. Davies today, because I think at one point he touched on the United States court case, United States versus Richard Nixon, regarding the release of the Watergate tapes, which was a seminal decision by the United States Supreme Court. And of course, I recognize that it's not jurisprudence here, but it's a very, very important case. But more than that, it reminded me of a widely known and reported conversation that took place between then former White House counsel John Dean and President Richard Nixon, where John Dean said to the president, "Mr. President, there is a cancer upon the presidency." Well, Mr. Chair, I want to say to you today, it's time to turn over these documents because there is a cancer on this Prime Minister and on this government. Thank you.
Thank you, Mr. Morantz. We'll go now to Ms. O'Connell. Go ahead, please.
Thank you, Mr. Chair. And I really sincerely hope that the members of the opposition don't start charging rent for how much I am living in their heads right now. I find it particularly interesting when you have a very weak argument, instead you go to personal attacks. And that's all we've heard in this last ramblings. In fact, so let me do a little bit of a recap here. So what we heard today was that thousands of pages or documents, however you want to define it, were provided to the law clerk. They are continuing to be provided in unredacted forms when appropriate. The law clerk confirmed that. He also confirmed that the government has never indicated that they are withholding anything. In fact, he confirmed that the documents are still being produced. In fact, he also didn't argue in any way, he didn't take the bait from the opposition to say that the government was in any way in a breach. He clearly said he is continuing to do his job. He is receiving the documents that are being provided. So I think the Conservative and NDP coalition big day today was, to try and get some gotcha moment that just didn't happen, because it's not happening, because the government is providing the documents. So that's a quick recap. And then, so what's happened here since then is this whole kind of like throwing of spaghetti to see what sticks. Mr. Moran spoke about national security. Nobody in the motion before us, nobody's talking about national security. He perhaps is at the wrong committee. The reference to national security was simply some of the parameters in the House motion for redactions, but the law clerk never suggested that any of the documents from the October 26th motion was not being complied with. In fact, he says he's still receiving them and that work is still ongoing. So then what did the Conservatives do? I mean, they call this a dictatorship. They refer to Watergate, Richard Nixon. I mean, has there been a substantial argument on the facts before us? No, it's nothing but name calling. This is the Conservatives' big moment. Documents are being presented. In fact, over 8,000, I think the clerk said over 6,000 documents have been provided to this clerk. I received notification of them. And guess what? Not a single member of the opposition has called to have a meeting to review any of those documents. We haven't had a meeting talking about them. The Conservatives just received them. So the conspiracy theory that I'm referring to is the fact that there's this conspiracy theory that there's some big set of documents that aren't being provided and they don't receive anything. In fact, they've received the documents, and what they're not telling Canadians is there's no scandal in them. So let's pretend that there's some big thing here that's missing. Reminds me of in the US, the big lie. There's no scandal in the documents that they've received, the thousands of documents they've received. So now it's about innuendo of what else is out there. Well, Mr. Chair, let me then move on to the next part that was brought up. Mr. Lawrence and I forget who else mentioned it, but they talked about the contracts. The contracts are at the base of this issue. Mr. McGuire said that. The contracts are at the base of this issue. Mr. Lawrence said, it's simple. It's simple. Well, Mr. Chair, I have the October 26th motion in my hands right now. It is 4 pages long. There are 30 clauses in this motion. The opposition even included an amendment through the process. 30 clauses, 4 pages, not a single mention of vaccine contracts. How simple is that? I think what has happened here is the Conservatives went on a fishing expedition with the NDP and nothing came up. So then they get into revisionist history with what I keep referring to as the Barlow motion. Because again, Mr. Chair, 4 pages, 30 clauses, not a single mention of vaccine contracts that the Conservatives say is at the heart of this. So they have a funny way of showing what's at the heart of something. There's been more mention of personal attacks on me than vaccine contracts by the opposition today. So I think Canadians can see through the games. But after the October 26th motion was put in place, 30 clauses, 4 pages, no mention of vaccine contracts. After that was put in place, the Conservatives realized, oops, we didn't mention that. So here in walks the Barlow motion on February 5th. And in this motion, they actually acknowledge in the 3rd paragraph, I kept referring to it today, that if the law clerk does not have such documents, well, if it was so simple and in the October motion or order of the House, why would you put in a provision like that? It's because it didn't exist. And so the Conservatives are trying to rewrite history. But when you take the Barlow motion, it clearly says that if the law clerk doesn't have these documents, because the law clerk was never required to have those documents, it sets out parameters of how these documents should be shared with the committee. So what happened was, Mr. Chair, here's the big thing that the Conservatives don't want Canadians to understand, is that it asked for the vaccine agreements with the suppliers, that they be tabled with the committee in both official languages, and that the documents be vetted in accordance with the parameters set out in the House of the motion. The law clerk confirmed that was done. The documents were provided to the members of this committee. They were provided in both official languages, and they were set out with the parameters of the motion. The vetting was done based on the parameters of the main motion. The difference is, what the Conservatives are trying to argue, is that the law clerk should have done the vetting. But if the members of the opposition wanted that, why didn't they include it in their motion? It is not the government's fault that the Conservatives create this web of lies and confusion and procedure upon amendments and motions and orders that don't actually make sense. And then wonder, and then come back and say, the government never did the thing we never asked them to do. No Canadian would see this as a logical way to do business. So the government instead, in an attempt to be as transparent as possible, said, here are the documents. They're in both official languages, and we've vetted them based on the parameters of the October motion. The government complied. And the Conservatives are so unused to the government because when they were in government, these members are so not used to committees actually receiving this information that I think their heads exploded and they didn't know what to do. So I guess to conclude, Mr. Chair, I'm pretty animated on this because I feel like it is such a misuse of this House and the insults that have been said, that this is somehow a dining club, that, why are we here? Well, if the members want something to do, why don't they go through the thousands of documents that have been provided to them? Why don't they speak to Canadians about those documents? It's because there's no scandal. So the only thing Conservatives know how to do is make up conspiracy theories, suggest that there is some horrible thing happening and Canadians just need to know about it. But when you actually look at the facts in front of you, I think it says a lot that the Conservatives actually try, and the NDP actually tried to filibuster their own motion today because they know they don't have legs to stand on. And instead they resort to personal attacks, name calling, referring to this as a dictatorship that provided all the documents. I think they have a pretty messed up view of what a dictatorship looks like because we complied with the motion. It's not the government's fault that their motion doesn't make sense. It's not the government's fault that the October order didn't include vaccine contracts. The government complied with it. It's not the government's fault that after 30 clauses, 4 pages, not a single reference to vaccine contracts, and now the Conservatives propped up by the NDP are crying conspiracy theory, are crying that there's some, horrible thing happening here. And my last point, Mr. Chair, I think it's pretty horrible that I couldn't disagree more with Mr. Lemire comments about vaccines being too expensive. I'd be super curious to know what he thinks the price of one of his constituents' lives are. He wanted us to wait and not purchase vaccines, but I would say, Mr. Chair, that we work to save lives, to procure vaccines for the saving of those lives, and I think his constituents would be very interested to know that he felt we spent too much money trying to save their lives. So I think what we have here is a classic case of the Conservatives really not having any facts to back up their accusations. So instead they turn to innuendo, name calling. That's fine, Mr. Chair. I think Canadians can see right through it because we have the documents right in front of us. Committee has been provided thousands of pages and not a single thing has been raised by these committee members. So I think that says it all. Thank you, Mr. Chair.
Thank you, Ms. O'Connell. I'm obliged to inform the committee that our time is up. We were committed to 2 hours. We're well over that time. And I see there's a whole list of people left to speak. So I would like to, I'd like being at the end of the session, I would like to thank the clerk and the interpreters for their steadfast patience in being with us all this whole time through many months and if not years. I would also certainly like to thank the House administration and all the people behind the scenes who make this place function. And I would also like to give a big shout out as well to the interpreters to thank them all. So I do have a number of 4 speakers left, but we have no time for it. We will not get to a vote on this matter today. I would ask if there's consensus to adjourn at this time, and we can deal with this at another time. Is there anyone who opposes? Seeing none, I will, therefore, we are adjourned. Thank you all and for all your hard work now and throughout the time. So thank you all.